This week, we took a look at the issue of social equity. Social equity is fairness in the delivery of public services. It is the principle that each citizen, regardless of economic resources or personal traits, deserves and has the right to be given equal treatment by the political system. Government organizations have a special obligation to be fair, to pursue social equity both with their employees and the public, because they represent the citizenry. This is in distinct contrast to business organizations which represent private interests such as stockholders. There is a long tradition of government forcing or mandating private organizations to better treat their employees. As early as 1842, Connecticut and Massachusetts legislated a maximum 10-hour workday for children. In 1848, Pennsylvania established a minimum working age of 12 years of age for factory jobs. But it would be more than 20 years before any state had inspectors to enforce such child labor laws. And it would not be until the late 1930s that federal laws would outlaw child labor, mainly through the Fair Labor Standards Act of 1938. The whole thrust of the labor and women's movements that began in the 19th century and the post-World War II civil rights movement was to obtain legislation that would equalize the employment and social prospects for unions, women, and minority groups. It was H. George Frederickson who discussed and discovered the term New Public Administration. His paper, titled Towards a New Public Administration, called for social equity in the performance and delivery of public services. Frederickson's New Public Administration called for a proactive administrator with a burning desire for social equity to replace the traditional, impersonal, neutral, gun-for-hire bureaucrat that had traditionally been the town manager or the county official. The United States has made great efforts to be a country of equality and opportunity for all. Unfortunately, the history of the United States shows very different outcomes. It was Associate Supreme Court Justice Thurgood Marshall who pointedly rejected the view that Americans should celebrate the Constitution as a source of all that is good in the nation. It is he who said of the founders that the government they devised was defective from the start, and it required several amendments, a civil war, and momentous social transformation to attain the system of constitutional government and its respect for individual freedoms and human rights we hold as fundamental today. Despite his harsh rhetoric, all discussions of equality in the United States must begin with the issue of race. Race can be defined as a large group of people with common characteristics presumed to be transmitted genetically. What characteristics are properly to be included has been a subject of debate, however. Up to the middle of the 20th century, race was used as a way to distinguish among national groups. A racist can be defined as any person or organization that either consciously or unconsciously practices racial discrimination against a person on the basis of race or ethnicity, or supports the supremacy of one race over others. The history of slavery in the United States is still relevant today because of its underlying basis for African American claims for special treatment. In September 1862, it was President Abraham Lincoln who issued the Emancipation Proclamation, which declared that all people held in slavery are and henceforth shall be free, and the executive government of the United States, including the military and naval authorities thereof, will recognize and maintain the freedom. This was codified into the Constitution with the passage of the 13th Amendment in 1865. America is not the only nation to struggle with issues of race and racism. Nelson Mandela of South Africa fought his country's oppressive apartheid for several decades before his people were able to be equal to the whites in South Africa. The 13th, 14th, and 15th Amendments attempted to settle the issues of slavery and civil rights. There were two major Supreme Court rulings dealing with these issues, and they went in very different directions. In 1896, the court held in Plessy versus Ferguson that segregated railroad facilities for African Americans, facilities that were considered equal in quality to those provided for whites, did not violate the Equal Protection Clause of the 14th Amendment. This was a serious blow to those seeking to bring the races together. In 1954, the Supreme Court issued another ruling in Brown versus the Board of Education of Topeka, Kansas. The court decided that the separation of children by race, and according to the law in public schools, as allowed in Plessy versus Ferguson, generates a feeling of inferiority as to the minority group's status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Consequently, the court held that separate education facilities are inherently unequal, and therefore they violate the Equal Protection Clause of the 14th Amendment. This was a significant ruling by the Supreme Court and led to dramatic changes over the next 50 to 60 years that are ongoing even today. Equality in employment opportunity is another critical area that the United States has struggled with. Equal employment opportunity generally applies to a set of employment procedures and practices that effectively prevent any individual from being adversely excluded from employment opportunities on the basis of their race, color, sex, religion, age, national origin, or other factors that cannot lawfully be considered in employing people. Affirmative action first meant the removal of artificial barriers to the employment of women and minority group members. Special efforts were made to bring more members of minority groups into the federal service. The Equal Employment Opportunity Act of 1972 solidified the Civil Service Commission's authority in this area. It reaffirmed the traditional policy of non-discrimination and empowered the Commission to enforce its provisions. The case for affirmative action is based on statistics. It calls for special efforts to recruit and advance minorities and women in employment. Statistically, there are great disparities between these groups and whites in hiring, in pay, and also in home ownership and the ability to get mortgages for home, to purchase homes. These disparities exist because of continuing patterns of discrimination that are easily traced back to the days of slavery. The only way to overcome and get beyond the adverse impacts of systematic discrimination is to implement a vigorous affirmative action program. To repeal affirmative action and force minorities to compete on a proverbial level playing field would only perpetuate the existing pattern of discrimination. Table 12.1 on page 446 outlines a chronology of affirmative action in the United States. However, there is also a case against affirmative action, and it basically comes down to the fact that it is, by those who oppose affirmative action, simply unfair. Well-meaning opponents of affirmative action hold that race or sexual discrimination is wrong no matter who does it, including discrimination against whites. Despite its best intentions, affirmative action programs have had the effect of stigmatizing minority workers as those who got their jobs not because of their intrinsic merit, but because of pressure to fill a formal or informal quota. Opponents of affirmative action argue that if compensatory benefits are to be provided, they should be based on class, not race. There's also the issue of reverse discrimination. Reverse discrimination is a practice generally understood to mean discrimination against white males in conjunction with preferred treatment for women and minorities. The practice has no legal standing in civil rights laws. The textbook also describes a variety of non-racial forms of discrimination. They include sex discrimination, sexual harassment, discrimination against pregnant women, discrimination based on age, discrimination for having a disability, and discrimination based on sexual orientation. These are outlined in great detail in the text, and you should read them. This concludes this week's lecture. Please complete all the readings, including the readings outside the textbook, before completing the assignments and discussion questions. Good luck.